Let's look at your damages. $4,042. The fair market value of your car is $3,069. Why should we give you more money than the car is worth?
I just thought it was like the safest choice to go with the highest estimate that I'd got, because I figured I wouldn't, like how court systems work, I might have not gotten like the full amount that it would cost.
You submitted one for $4,042, and how much was the other one?
$3,300, around there.
And your countersuit is premised on your argument that she's at fault.
Yes.
Even though my colleagues have explained to you how the physical damage on your cars isn't consistent with your story.
Yes.
I don't have anything further.
Then, ladies, we're going to excuse you while we deliberate in this matter. Thank you. You know, I think that the defendant's initial statement as to where she was driving, I think, was just an inadvertent confusion. Right. But the bottom line seems to me to be that the plaintiff was indeed the one who was hit by the defendant and that her vehicle was damaged when she came into her lane. I agree with you, Judge Acker, about the damages. They would exceed the value of the vehicle. However, we have two uninsured drivers. You want to work it out outside court because you're both uninsured? Then go ahead, be my guest, do it. But for us to kind of ratify their non-insured driving, I have a real problem with that. So if somebody had to prevail, obviously it would be the plaintiff who would prevail here for the amount of not to exceed the value of the vehicle. But I'm leaning towards not wanting to give anybody a penny.
Well, I think that'd be a problem because this was tried in another venue. A jury wouldn't take the insurance situation into consideration.
Why?
Because you could always sue for damages and not go through your insurance company, I guess. In any event, I don't think this is the case to send that message on.
If we were ever going to establish such a hard, bright line rule, and I'm not sure that we should, but we might, but I'm not sure we should. We shouldn't do it in this case. I don't think these
I don't think the plaintiff assumed that it was an assumption, and that was the real problem, that her parents or family had her insured. And
okay, I mean, look,
wasn't included in the insurance.
As I said,
share your frustration.
Yeah, I mean, and as I said, it's pretty clear from the evidence that she, in fact, should recover for those damages. But I think a strong message has to be out there that, okay, this is not the case, but at some point there's going to be a case where we might create maybe not such a bright line, but, you know, a mediocre.
A gray line.
A gray, mediocre line. Okay, so I think we're unanimous. We're going to award the plaintiff the money, and I'm going to yell at them both for not being insured.
Yeah, good.
Great.
This courtroom is again in session.
Ms. Munoz, you did demonstrate to us that it was the defendant's negligence which caused the accident. And so we are unanimous, ma'am, in finding a verdict in your favor. However, we are not going to award you the money that you've asked for because that exceeds the actual value of the car, which is $3,069. We will give you that. That should make your vehicle whole. So for you, the verdict is unanimous as to $3,069. Ms. Bell, I'm sorry to say we are not going to award you anything on the counterclaim as we found that you were solely responsible for this accident. Okay. And so that case will be dismissed, and we are also unanimous in that verdict. Ladies, you can't get behind a wheel either unlicensed or uninsured or just thinking that you're insured, either one of you. It's just unacceptable and always the worst time when something like that happens. Please go safely, drive only insured. Thank you.